So in this video, I have a very important update in a major case against a statewide ban on the possession of magazines that hold more than 10 rounds, and also the mandatory permit that the state put in place. This challenge has now been granted review by the state Supreme Court, and it is set for oral arguments very soon. So let's talk about what is happening in this critical case. Now, before we jump into this video, I want to ask you guys for a favor. If you want to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, double check to make sure YouTube is not unsubscribed you, because they especially love to do that on two-way channels. A lot of people don't know that they've been unsubscribed. And also, I want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always expanding their benefits and what you can have in your coverage. If you're interested in what, in my opinion, is the best self-defense program on the market, check out AOR using the links down below in the detail section, also in the pinned comment. And if you use my code ARMEDSCHOLAR, you can get $50 off of your individual sign-up plan or $25 off of a family plan. Now, as I mentioned in the intro, in this video, we're going to be discussing a challenge against a state magazine ban and also the permit to purchase process that they put in place. Oregon Measure 114, which put in place a statewide permit to purchase, and that magazine ban was recently ruled unconstitutional and struck down in its entirety by a state court with a permanent injunction. Well, recently the Oregon Court of Appeals issued a unanimous order upholding the magazine ban and the permit to purchase process, and that decision went against the permanent injunction, but now this case is heading to the Oregon State Supreme Court, and the State Supreme Court has granted review to the case and now has set oral arguments to take place in this critical challenge on November 6th. Now, the case we're talking about in this video is called Arnold versus Kotek. This case challenges Oregon Measure 114 as a violation of the Oregon State Constitution. Measure 114 first requires that anyone purchasing a firearm must obtain a permit to purchase. And then the second significant thing that this measure did is it created a ban on the sale, purchase, transfer, or possession of any magazines that hold more than 10 rounds after the effective date of the measure. In response to this measure, this Arnold case was filed in a state court, and Judge Robert Rocchio ruled in this case that Oregon Measure 114 was invalid under the state's constitution and must be struck down in its entirety with a permanent injunction. But of course, the story does not end there. Oregon then decided to appeal that ruling up to the State Court of Appeals. It's important to note that since this is a state challenge under the Oregon State Constitution, there's a little bit different of a standard for the state court to determine the constitutionality of this state law and essentially whether it violates the Oregon State Constitution about the Second Amendment and how firearms laws operate within the state. Now, under this standard, Oregon applies kind of a two-phase test, so it's a little bit different. Under phase 1, there is a determination of whether Article 1, Section 27 of the Oregon State Constitution even applies. The plaintiffs argue that these are protected items, and they state that the Supreme Court itself has said that these are protected arms, and these types of arms are, modern instruments that help facilitate armed self-defense and therefore should be protected. Now, the second phase of the test here in the state of Oregon almost looks at the public's interest, and it is a balancing test here in the state, and it balances the harm on the constitutional right against what's in the public's best interest. Of course, in Oregon Measure 114, it argues that the measure is in the public's best interest to stop crime and to stop all of these claimed harms. However, the trial court, on review of that, through expert testimony and data, they found that the public harms were overblown in the measure and that this restriction on a constitutional right doesn't even meet that claimed interest here in the measure. This case eventually made its way to the Court of Appeals, who recently decided to side with the state of Oregon and strike down Judge Rocchio's permanent injunction. They held that all of ballot measure 114 is facially valid because the law is capable of some constitutional applications. In essence here, all the Court of Appeals believe that really matters is whether there is a claimed public interest or a public safety threat caused by these magazines, and if the public's safety and benefits are best served by restricting these items. But that decision by the Oregon Court of Appeals is now up for review in the Oregon State Supreme Court. The Oregon State Supreme Court will now hear oral arguments in this case, and those will take place involving the permit process and the magazine bans on November 6th. The Arnold plaintiffs recently submitted their opening brief, and they argue that the consistent case law in the state of Oregon holds that the constitutional restrictions on arms must have pre-1859 historical analogs demonstrating that Oregon's constitution and its drafters understood these types of laws were constitutional. The court's case law identifies two types of analogs and restrictions. One, laws prescribing dangerous manners of possessing or using arms, or two, laws restricting certain groups of dangerous criminals from being armed. Defendants did not attempt to support any other historical analog. They also state consistent case law holds that prescribing the mere possession or use of protected arms is always unconstitutional. Rather than analyzing history or applying earlier holdings, the opinion of the Court of Appeals adopted a subjective reasonability test foreign to case law and devoid of objective criteria. The opinion concluded that Measure 114 is reasonable because it does not ban all firearms and eventually allows Oregonians to obtain firearms. Under the correct analysis, Measure 114 and its provisions are not remotely analogous to any law that was upheld or used prior to 1859. Moreover, because the opinion held that so defined magazines that hold more than 10 rounds are constitutionally protected arms, the opinion should have adhered to the doctrine of stare decisis and held that Section 11 is unconstitutional. So this is great news for those of you in the state of Oregon, but also other states that currently have these type of state bans on magazines, and then also a permit process that was put in place to purchase, firearms, handguns, rifles, and all those items. The state Supreme Court here in the state of Oregon will now consider if a state can put in place a magazine ban and also a permit process to purchase these types of items. Now, the Oregon State Supreme Court does in fact lean left, but regardless, this sets up a major state magazine ban and permit challenge to kind of now be wrapped up and eventually make its way to the United States Supreme Court as well. There's currently another case out of the state of California. It's a federal challenge to the state of California's magazine ban, which is seeking Supreme Court review. But this would be kind of a nice 1-2 punch coming from a state level dealing with magazine bans and a permit process to potentially make its way out of the Oregon State Supreme Court, then make its way to the United States Supreme Court to further bolster those challenges against magazine bans and permit processes. So this Oregon magazine ban and permit process will now be argued in front of the Oregon State Supreme Court on November 6th at 9 a.m. It's going to be interesting to hear the questions that the Oregon Supreme Court asked, and generally you can kind of get a good sense of how the court is leaning based on those arguments and hypotheticals. Like I said, this court does lean left, but when it comes to this specific case, multiple times the Oregon State Supreme Court has refused to get involved. So it doesn't appear that there is this default always ruling in the favor of the state of Oregon on this specific issue. So we're going to get a better idea during these arguments about maybe how the Oregon State Supreme Court is going to lean on this issue. So as we get more information, as this unravels after those oral arguments, I will let you guys know. I also want to mention that if you guys want to support this challenge, especially if you're in the state of Oregon, I'm going to leave a link down below to a GoFundMe, I believe. It's for the attorney here who's litigating this case. He's taking this up and challenging it all the way to the Oregon State Supreme Court. So if you're in Oregon, consider supporting this challenge. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.